Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
They have not broken with the president yet. I have zero faith that Donald Trump can't convince 2 out of 3 of Roberts, Kavanaugh, and Barrett to go along.
Right. And if he fires Powell, look for all hell to break loose, because that will be an unmistakable klaxon signal that monetary policy is going to be subordinated to politics. Welcome to Law and Chaos, where the Supreme Court's failure to do its job is causing chaos and jeopardizing the entire economy. The president wants to fire Fed Chair Jerome Powell, and walking man bun Justin Baldoni is back to teach us some more civil procedure. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you?
I'm all right. I'm looking forward to the weekend. How about yourself?
I am also looking forward to the weekend, although, that never means time off for either of us. But
I mean, we're doing okay. We're doing better at our time management. Okay,
Fair
but we
enough.
do have much to say today. So,
yes, we do.
Quick docket alert. This is a message sent by Maureen Comey, daughter of James Comey, who needs no introduction. Maureen Comey was, until yesterday, a high-ranking prosecutor at the Southern District of New York. She prosecuted the Diddy trial. She was the lead prosecutor in the Diddy trial. And she prosecuted Ghislaine Maxwell, girlfriend and procurer for Jeffrey Epstein. Which, look, if you were trying to show to everybody that there's a cover-up, I don't know what you would be doing differently. They're in the middle of this maelstrom where their own supporters think that they're hiding something. And here he is firing the Epstein prosecutor. It seems an odd decision.
Right, but she was always getting fired for her last name.
She didn't, though. It's been 6 months.
Well, fair, but, Trump's memory is long for only one thing, and that is people that he thinks have wronged him.
Fair enough. Okay, so let's read this. Maureen Comey says, yesterday was unexpectedly my last day in the office. I was summarily fired by a memo from Maine Justice that did not give a reason for my termination. Every person lucky enough to work in this office constantly hears 4 words to describe our ethos. Without fear or favor, do the right thing the right way for the right reasons, without fear of retribution and without favor to the powerful. For the majority of my nearly 10 years in SDNY, the hard part seemed to be acting without favor. That is, making sure people with access, money, and power were not treated differently than anyone else, and making sure this office remained separate from politics and focused only on the facts and the law, which would certainly imply that she felt the same way during the Biden administration as she did during the Trump administration.
Mm-hmm.
She goes on to say, fear was never really conceivable. We didn't fear bad press. We have the luxury of exceptional security keeping us physically safe. And so long as we did our work with integrity, we would get to keep serving the public in this office. But we have entered a new phase where without fear may be the challenge. If a career prosecutor can be fired without reason, fear may seep into the decisions of those who remain. Do not let that happen. Fear is the tool of a tyrant wielded to suppress independent thought. Instead of fear, let this moment fuel the fire that already burns at the heart of this place, a fire of righteous indignation at abuses of power, of commitment to seek justice for victims, of dedication to truth above all else. It has been an honor to fight for these principles by your side, Maureen.
Yeah, Here. I mean, on one very, very basic level, right? We've talked about feeling a tiny bit uncomfortable lionizing prosecutors.
Yeah.
But
Yeah.
I'd like to get back to that, right? I mean, this is somebody who's been a dedicated public servant, was equally critical regardless of who was in office, and who has been dismissed without reason or explanation for the reasons that I think she describes.
Okay, we have 3 stories to talk about in this segment, and they're all about what happens when the court refuses to do its job. Specifically, when judges refuse to step up to the plate and counter a president behaving like an autocrat and shredding the Constitution. Those stories are tariffs, Trump trying to fire the Fed chair, and the Senate is now shoving through a judicial nominee who is the subject of a contempt investigation. These are all independently terrible stories, but they are a symptom of a larger problem, which is that judges are not doing their jobs. I guess I should amend that to say, I think trial judges are doing their jobs almost across the board, but the Supreme Court and the appeals courts, not so much, or not consistently. Let's start with Trump's threat to fire Fed Chair Jerome Powell. We wrote about that on the blog at lawandchaospod.com. It is not paywalled, and I do hope you'll go read it. But I want to talk about it here, too, since this is potentially a market-crashing disaster, and it can be laid squarely at the feet of the Supreme Court. So for background, the Federal Reserve is America's central bank. It's responsible for ensuring the health of the U.S. banking system. And one of its main tools is that it gets to set interest rates.
Yeah, and to be precise, the Fed doesn't dictate rates directly. So what it does is set several key rates for the loans that it administers to large banks. And then those large banks peg the rates that they loan out money to that Fed rate. So the prime lending rate, generally the lowest possible rate at which a bank will loan anyone money, is the federal funds rate plus typically 3%. Right now, the federal funds rate is a target of 4.25% to 4.5%. So that makes prime 7.5%, which, if you're like us, where we are the same age,
really?
and, you bought a house during pretty much any of the last 20 years, like a prime rate of 7.5% feels crazy high. But the reality is that it's high. Like historically, prime averages less than 7.5%. It's not crazy high, right? Like the prime rate was 8.5% as recently as 2023. It was 9% in 2001 and 1995, and it was 13% in June of 1984, which was right before Ronald Reagan won a 49-state landslide. But that being said, we should not be surprised that Donald Trump, a real estate guy who built his fortune using other people's money, wants to go back to the days of essentially a 0% federal lending rate.
Yeah, look, I was in real estate. Those days were amazing. But I remember the moment in 2005 when I knew that the music was about to stop because money was free. And so everyone and their mother was plowing insane amounts of cash into investment properties. And I was at this auction with my baby in a stroller. And I watched this building sell for 3 times what I thought it was worth. And I knew it was time to get out now, which I did. But that's kind of the point with the Fed, right? When it's cheap to borrow money, people do, and they spend it and they stimulate the economy, and it's all good right up until it's not, because too much money sloshing around causes inflation. And so the Fed is always trying to hit that sweet spot where people feel good enough to borrow, but not so good that they go crazy and spend, say, $600,000 on a gut rehab that's going to rent for $3,500 a month. And I hate to harp on it, but honestly, it was like an out-of-body experience for me. I remember so clearly being like, oh, it is time to go. Anyway, so when it gets overheated, the Fed will raise the rates. And when things are slowing down, the Fed will drop them, which is why they dropped the rates in 2020 and 2021 to counteract the effects of COVID and stimulate the economy. And then they raised them in 2022 so that they'd have something in the pantry to throw at the next crisis.
Right. And the practical effect of that is that it always puts the president in conflict with the Federal Reserve, because what the president would like is always to accelerate the economy, right? Have the foot on the gas all the time, make people happy, spend money, thank the president, and, let the next guy eat a plate full of vegetables. And that is why balancing out that impulse is why the Fed must be politically independent, right? Because when it's not, you run the risk of catastrophic hyperinflation, like, say, Argentina, which is currently at a 39% inflation rate, which sounds insane until you realize that it was 271% a year ago. And okay, that's a country with a lot of different challenges. But let me climb on my soapbox for a minute here, because Donald Trump is squandering all the things that made America great, right? The dollar is the world's reserve currency because we place limits on how politicians can screw with it. When we make a promise to our allies, we usually mean it. And the exceptions are the exceptions, not the rule. Trump wants to cash all these checks that draw on our relative economic and soft military power, but he doesn't understand that once you train your account, those checks will bounce, right? Like, American universities will not remain a destination for the best students around the world if we screw with the visa system to keep out foreign students and eliminate the Department of Education and keep out domestic students, right? If the dollar is no longer the reserve currency, if USAID isn't acting as an agent of American soft power, if Trump actually makes good on his threats from his first term and defaults on U.S. bonds, there's no reason we can't wind up in the same place as Argentina. And that's why it is so critical for institutions like the Fed and the courts to be independent of the president.
100% agree. Okay, we're going to take a quick ad break unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod, in which case there will not be an ad break. You will go right directly to listening to us talk about Jerome Powell. Hang on, guys. And we're back. Okay, so Jerome Powell is in office until May of 2026 and says he intends to serve out his term. Trump, however, really dislikes Powell, said during the campaign that he didn't want to keep Powell on, and since he has returned to office has been constantly shitposting that Powell needs to lower interest rates ASAP. He says, "Too late, Jerome Powell is a fool who doesn't have a clue. Other than that, I like him very much. Oil and energy way down, almost all costs, grocery and eggs down, virtually no inflation, tariff money pouring into the U.S., the exact opposite of too late, enjoy."
Remind me again, which president appointed Jerome Powell to the Federal Reserve?
Yeah.
Donald Trump. Anyway, all of that is, as usual, wrong. Eggs are averaging $3 a dozen, which is exactly where they were on election day of last year. Groceries are up. They are rising faster than inflation. And oh my God, the tariffs. The tariffs are not making us richer. They are by definition inflationary. They literally raise the price of goods.
Right, which is one of the reasons that the Fed keeps not lowering rates, even though Trump exhorts them to do it, because inflation is low, but it is ticking up thanks to Trump's stupid tariffs. I mean, he's such a tin pot dictator, right? The economy is still humming along, and he's demanding like a shot of cocaine laced with adrenaline to juice it even more. Right. So the question here is, can Trump fire the Fed chair? And that answer should be an obvious no, right? Under 12 U.S.C. Section 242, each member of the Board of Governors shall hold office for a term of 14 years from the expiration of the term of his predecessor, unless sooner removed for cause by the president. And removal for cause does not mean we just have a policy disagreement.
Right.
But thanks to the Supreme Court's conservatives, that's not at all clear, right? We've talked on the show a lot about all these executive branch agencies, which were established by Congress with specific statutory protections saying the president cannot fire their head or their board members. And in every single instance, the Supreme Court has said, oh, actually, he can.
Yeah. Let me rewind the tape here for just a second, because this is the Supreme Court openly rewriting history. For basically the last 100 years, the law has been shaped by two cases, Humphrey's Executor from 1935 and Morrison v. Olson from 1988. Humphrey's Executor said Congress has the power to create executive branch agencies and set restrictions on how the president could remove the heads of those executive branch agencies. Here's what the Supreme Court said in 1935. We think it plain under the Constitution that illimitable power of removal is not possessed by the president. The authority of Congress cannot well be doubted, and that authority includes the power to forbid their, meaning heads of executive branch agencies, removal except for cause. Okay, and that was continued in an unbroken line of cases through 1988, the Supreme Court in Morrison v. Alston. And again, I just want to quote from Chief Justice William Rehnquist, who described the state of the Constitution thusly. The real question is whether removal restrictions are of such a nature that they impede the president's ability to perform his constitutional duty. We cannot say that the imposition of a good cause standard for removal by itself unduly trammels on executive authority. We simply do not see how the president's need to control the exercise of that discretion is so central to the functioning of the executive branch as to require, as a matter of constitutional law, that an executive branch head be terminable at will by the president.
Right. And Rehnquist worked for Nixon. He was certainly a fan of untrammeled executive power.
Right. And your point is, let me kind of spell it out. No one on the farthest fringe of the right, except Antonin Scalia, thought that it was unconstitutional for Congress to check executive power. I mean, at least not until 2020, when this right-wing Supreme Court really, really, really wanted to let Trump fire the head of the Consumer Financial Protection Bureau, even though Congress said that he couldn't. So the Supreme Court magicked up a new rule in a case called Saylor Law v. CFPB. See, now it's perfectly okay for Congress to protect the chairman of a multi-member board from being fired at whim, but not the sole director.
Yeah, so that rationale was completely made up, and it appeared nowhere in the prior case law. But okay, fine. If that's the new law, at least it should protect Jerome Powell because the Federal Reserve is a multi-member board. Mm-hmm. Except that the 2020 Roberts Court is not supine enough for the 2025 Roberts Court. And so on May 22nd, in a case called Trump v. Wilcox, the Supreme Court's 6 conservatives blocked lower court injunctions that were preventing Trump from firing the heads of the National Labor Relations Board and the Merit Systems Protection Board. Each of those are also multi-member boards, and each one had language in its establishing statute in which Congress intended to protect the head from being fired except for cause. Right. And both the plaintiffs and the amici in Wilcox warned the Supreme Court, hey, if you let Trump fire us, he can fire Jerome Powell too, and that will be very bad for the economy. In fact, the amici said staying the district court's judgment in this matter could shake belief in the Fed's capacity to act independently in formulating monetary policy and addressing financial instability, and the court cannot easily avoid these consequences by simply announcing a Fed exception. But that's exactly what the Supreme Court went with. They penned this 2-sentence Fed exception. They said, respondents Gwynne Wilcox and Kathy Harris contend that arguments in this case necessarily implicate the constitutionality of for-cause removal protections for members of the Federal Reserve's Board of Governors or other members of the Federal Open Markets Committee. We disagree. The Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. See Saylor Law.
Well, surely Donald Trump will be dissuaded by a couple of sentences of dicta on the shadow docket after the Supreme Court has basically told him that he's a God king who can break the law at will.
Yeah, I mean, why would the president listen to this, finger wagging now, right? They ensured that he could never be prosecuted for crime. They refused to rein him in when he's stealing Congress's power. And I mean, honestly, everything that is happening right now can be laid squarely at the feet of Chief Justice Roberts.
Yeah, agree.
And let's be clear, firing Jerome Powell will not get Trump where he wants to go because the rate is set by a vote of the full Federal Open Market Committee. And if he wants to control the rate, he's going to have to fire all of them and appoint new ones. And I mean, why should he stop? What's stopping him from doing it?
Yeah, I have seen people say, well, the Supreme Court will stop Trump from firing Powell because they don't want to tank their own stock portfolios. And I got to tell you, that feels like wishful thinking to me, right? Like,
yeah.
The court's conservatives are totally captured by the right. And I mean by right-wing grievance politics,
yes.
right? By Sam Alito's insurrection flag, right? Like, they are fully insulated from the consequences of their own decisions. It's not like the Supreme Court has to pay for their own vacations or their kids' tuition or make payments on the fanciest tricked-out RV since Stripes, right? Like, yeah, look, right now, if you listen to this show, that Thomas, Alito, and Gorsuch are already an automatic vote for whatever Trump wants to do. They have not broken with the president yet. I have zero faith that Donald Trump can't convince 2 out of 3 of Roberts, Kavanaugh, and Barrett to go along.
Right. And if he fires Powell, look for all hell to break loose, because that will be an unmistakable klaxon signal that monetary policy is going to be subordinated to politics. No one is going to take the punch bowl away, and we're inevitably going to end up with hyperinflation, which is why the White House is taking a yes to all approach here, right? So first, Trump told congressional Republicans that he was going to fire Powell. That leaked, and people were like, oh, shit, and the market, dropped. And then he said, no, I wasn't. I was just asking them their opinion. But meanwhile, his henchmen, and by henchmen, I mean like people who work at the White House and are paid by your tax dollars, are shitposting all day, accusing Powell of fraud in conjunction with the renovation of the Fed headquarters. I mean, it's so ridiculous. It's a transparent attempt to cook up a justification to fire him for cause. And it's an ominous reminder, like in case you need one, that these people are wholly amoral and will say any untrue thing over and over in the media until it is treated among the base as accepted wisdom.
Yeah, and it's kind of their superpower or a super villain power. They have transformed all of politics into social media, and all they do is shout ad hominem attacks and lies, and it's working. And I would just say we are going to link that article that you wrote for the blog today at longcastpod.com in the show notes. Go check it out. We really do get into the details, and I think it's a great read. Okay.
Thanks.
We will be back with our next story after this brief ad break, unless, of course, you are a patron over at patreon.com/lawandchaospod or a subscriber to us on Substack, at which point no ads for you. Not today, not ever. And for everybody else, we'll see you on the other side.
And we're back. Okay, as we are recording this, there is yet another shoe dropping in the Jeffrey Epstein saga. It's disgusting. I mean, it's really disgusting. And I understand that the president is again threatening to sue the Wall Street Journal, which I mean, good luck. I don't know.
Well, to be clear, and I want you to say the story, but I thought this was so ominous when we read it. The response to this story was, I'm going to sue the Wall Street Journal just like I sued everyone else. Actual quote from the actual president of the United States. Maybe it was a terrible idea to elect this guy. Anyway, I'm sorry. I mean, I haven't gotten deeply into the story, but I guess we've all seen the supposedly creepy poem or whatever, haiku, innuendo, which Trump penned for Epstein's birthday or something like that. I have no comment on that. I do think, look, I'm not sure that this is a legal issue as much as it is part of a larger conversation that's outside the remit of this show about democratic messaging, right? Should we go totally in on offense on this thing that is not really a larger issue, in my opinion, because it so inflames Trump's base and it's a wedge issue for them, because knowing that is certainly what they would do for us. That is what they have done for us, to us for 10 years with extraordinary success. Yeah, I'm really torn on this one because on the one hand, use every arrow in the quiver to try and slow down Donald Trump, right? I get that. On the other hand, we got where we are by 30 plus years of the Republican base cultivating ignorance, conspiracy theories, fear-mongering. And I don't think we get out of it by, saying, but, you're on the wrong side of this. These are the people that stormed into a pizza place without a basement and demanded to see the children who were in the basement, right? They're impervious to reason, logic, facts. I don't know.
Yeah. So look, right. Obviously, right now, the right is aflame with discussion of Epstein's, quote, client list, which I don't believe exists as such. But are we supposed to treat this as a real issue and essentially feed the trolls who tell themselves a series of crazy lies about satanic child sex cabals, right? Because I'm not sure that feeding them is good for society generally. I think that, right. Okay, so look, most of that, as I said, outside my wheelhouse. But you know what is inside my wheelhouse? Making fun of demented law professors. Because, Andrew, your former teacher, Alan Dershowitz, Jeffrey Epstein's former lawyer, has an opinion piece in the Wall Street Journal. If I might summarize.
Excuse me. All right, move on. Nothing to see here. Please disperse.
Yeah.
I mean, he says there is no client list, but if there is, he knows who's on it, and it doesn't include any current office holders.
That seems very carefully worded.
I mean, Dersh is nothing if not careful. I mean, except when he's signing his name to Mike Lindell's garbage pleadings without reading them and then getting himself sanctioned. Anyway, he says there are no tapes except for ones of Epstein's living room, which were made when the police installed a video camera after there was a burglary.
I mean, okay, look, I know Alan Dershowitz is 85. Maybe this is the wrong thing about, but do cops install cameras in private residences?
I'm not sure about that one. Not to mention the DOJ just said they have hundreds of hours of tapes, which they cannot release because they contain child sex abuse material.
Right, of course they do.
Right. So Dersh says that Epstein wasn't a Mossad agent. Dersh says his pals in Israeli intelligence confirmed that. And he says Epstein definitely committed suicide. He ends by saying, sorry to disappoint you, but there is really nothing much to see here beyond what has already been disclosed.
Okay, so what I'm taking away from this is that Trump's entire cabinet, including Linda McMahon, is obviously on the Epstein client list, along with Caroline Leavitt, and that's why the Mossad had Epstein killed.
I think that's correct. I'm pretty sure that's how it goes. Yeah, it's just an enigma. No, I just threw up a little bit in my mouth because that was one of the little haiku things. Oof. Okay, but let's circle back and talk about tariffs, another gift from the Supreme Court. We talked about this in last Friday's subscriber bonus when Trump threatened to tariff Brazil 50% for daring to prosecute its former president, Jair Bolsonaro.
I never thought I would be making this from the other side, but yeah, functional democracies put people in jail when they try to mount a coup.
Right. But in this country, courts don't do their job. And so we've got a coup plotter burning down the country from inside the White House. So the challenge to Trump's so-called emergency tariffs went to the U.S. Court of International Trade. And the 3-judge panel there said, no, the president does not have the power to levy tariffs. That's in the Constitution. And shouting emergency doesn't change that. After which the Federal Circuit, which hears appeals from the USCIT, immediately stayed the order pending full briefing, which empowered Trump to impose these tariffs at will. And he has.
Yeah, I love that Trump announced that he was going to get 100 deals in 100 days or whatever. So far, they have, I think, maybe 3 deals, if defined as liberally as possible. Those are in principle. None of them are on paper. And then when the 100 days passed, Trump started sending out all of these insane letters saying he was imposing random tariffs on every country starting August 1st. If they didn't come, make a deal. And then when that didn't work, Trump just said, oh, yeah, the letters are the deals. And we just dictated the terms. So we win, America.
Yeah, I think he's going to do it this time. I mean, maybe not everything that's in those letters. I mean, he's already ratcheted up tariffs a lot, but not close to what he threatened. I do think he's going to impose some crippling tariffs that the markets haven't baked in yet because everyone just believes that he won't go through with it. Because that taco thing, right? Trump always chickens out. People saying that makes him nuts, and he's that boxed in by his own ego. So I do think in a couple of weeks, we're going to see some of these threatened tariffs go into effect. And it's going to be a bloodbath when the markets realize that they can't count on Trump to not do what he says he's going to do.
If the markets haven't learned by now. But look, this is totally on the courts. This issue is not a close one, right? While the Federal Circuit is chasing its own tail waiting for briefing, these patently illegal tariffs will, and in some cases have already gone into effect, right? At which point litigating is like trying to build a bridge while you're walking across it. I mean, what happens if the plaintiffs, right, those who have paid the illegal tariffs prevail, then what, right? Someone asked us on social media, what happens to all the tariff money collected if plaintiffs ultimately win at the Supreme Court? And I think the answer is that ultimately you wind up with thousands of claims at the U.S. Court of International Trade from importers who paid the tariffs and want their money back. And how you unmake that sausage, I do not know.
I mean, I think it's going to have to be a lot of checks, right? Or maybe a class action. Like, can you have a class action at the U.S. court? I mean, I don't know. I think that it is going to have to get unpicked.
Yeah.
Or the Supreme Court is just going to say, basically, the president gets to steal this congressional authority for permanently, which will be an absolute disaster, as will firing Jerome Powell. But thanks, Chief Justice Roberts.
Yeah.
Okay. Just one more example of the fallout from courts being unwilling to do their jobs. The Senate Judiciary Committee voted today to advance the nomination of Emile Beauvais to the Third Circuit, which means Trump's henchman, who ordered the DOJ to disobey court orders, is going to get a life appointment to the federal bench. Beauvais was the subject of that whistleblower report by former DOJ lawyer Erez Ruveni. So Ruveni says that Beauvais ordered immigration lawyers working for the DOJ to say F you to a court so as to ensure that the Alien Enemies Act immigrants who were being renditioned to SCOTUS in El Salvador would get on the plane and not come back. And he's got a lot of other allegations about Beauvais.
And Ruveni circulated hundreds of pages of emails and text messages that corroborate his testimony.
Right. So today, Democrats walked out of the committee meeting in protest after Chairman Chuck Grassley cut off deliberations, which is bad by the Senate, but it's also bad by the D.C. Circuit, since one of the emergency held panels, the appeals panels, stalled the contempt inquiry by Judge James Boasberg, the trial judge, and has put that inquiry on ice since April and hasn't done a damn thing with it since. I mean, would Beauvais have gotten a pass on this stuff if Judge Boasberg had been able to investigate this contempt?
Yeah, I mean, this Congress is pretty scandalously supine, but I guess we will never know what would have happened if the truth about Beauvais had come out. Right? Actually, this morning, the ACLU filed a motion at the D.C. Circuit saying, we still think you have no jurisdiction here. But if you're going to hold on to this case indefinitely, we'd like to supplement the record with Ruveni's whistleblower report. So, we'll find out.
Okay, we're going to take another break, and we will be right back to learn some Civ Pro with Justin Baldoni. Hang on, guys.
And we're back. Okay, time to confess. Liz, you and I cannot look away from the train wreck that is the Blake Lively, Justin Baldoni litigation. It's kind of a funhouse mirror of the real world that we inhabit as lawyers, right? Like, there is actual law going on, but then there's this public perception that is nearly unrecognizable. So it turns out, I think you and I both think that this becomes a really good vehicle to explain what the law actually is by contrast.
Yeah, I was trying to explain to a friend the other day why I'm so fascinated by this case. And I think it's because it's this confluence of legal documents, right? The thing you and I read all day long, and the parasocial ecosystem that arises around celebrities, right? And as a result of that, you have all of these people who are not lawyers reading court filings just like you and I do. And honestly, I think that's great. Like, the legal system belongs to all of us. That is why I'm such an evangelist for Court Listener, the public database of federal court documents, which should not have a paywall, but do. At the same time, you have all of these influencers purporting to translate these documents for clout. And the things they say to appeal to Justin Baldoni's fans are like nuts, right? They say stuff like, let's talk about how it's actually good for Justin Baldoni that his countersuit got dismissed. And like, no, it's not. In what universe is it good for a litigant to lose? Plus, look, in this case, you have one side litigating like normal people and the other side litigating totally for public perception. And you might win the war of public perception, but if you lose and you lose hundreds of millions of dollars, that's pretty bad.
Yeah, my favorite part of all of that was when Justin Baldoni's lawyer, Brian Friedman, we have discussed him on this show on multiple occasions, said he wasn't going to file a motion to dismiss Blake Lively's complaint, even though he totally could, because he didn't want to tip her off to everything wrong with the complaint. Like, he wanted her to be stuck with it. And just like, I'm at a loss for words. But no, that's not a thing, right? Friedman also said that he wanted to, quote, hold her deposition at Madison Square Garden, sell tickets or live stream it, and donate every dollar to organizations helping victims of domestic abuse, end of real quote, which, unsurprisingly, that nonsense came back around to haunt him.
Right. So Friedman has been implying for months that Blake Lively doesn't want to get deposed and won't show up because she knows she's lying and she doesn't want to get caught or whatever.
Yeah, look, being deposed is annoying, right? And if you're lying, you definitely wouldn't want to show up for your deposition because a good lawyer will methodically move through the evidence and almost certainly expose some contradictions in your story. Fine. But if you're the plaintiff in a lawsuit, you have to sit for a deposition. Blake Lively absolutely understood that when she filed her complaint. But yesterday, because of an interesting procedural hiccup, her deposition got postponed with the consent of all of the parties. So now everyone on the internet is saying, see, just like we thought, she's never going to show up. Judge Lyman is in the tank for Blake Lively.
Judge Lyman is not in the tank for Blake Lively. I'm not even sure Judge Lyman has ever seen a Blake Lively movie.
Yeah, he said on the record that until this case began, he had no idea who either Blake Lively or Justin Baldoni were.
Yeah. So, okay, like you said, Justin Baldoni's lawyer, Brian Friedman, voluntarily agreed to postpone Lively's deposition for 2 weeks. He did not have to. He could have gone ahead with it. He chose not to. But this is such a good vehicle to talk about civil procedure.
Oh, I know my walk-up music when I hear it. Okay, so let us start with Rule 30 of the Federal Rules of Civil Procedure that governs depositions. It says that, without leave of court, the default rule is that each side gets 10 depositions, right? 10 witnesses. You get to depose each witness once and only once, and you get 7 hours, excluding reasonable breaks. If you want more than that, you have to go to the court and ask for permission. Now, the court will give you permission if, and this is the language of the rule, needed to fairly examine the deponent, or if there's a delay caused by the witness or any other party, right? And the court can actually sanction lawyers and parties if they engage in bad faith delay in the deposition process. So what that means when people are doing real law is that both sides have an incentive to behave reasonably well, right? It's not perfect, right? But it's a pretty good balance, right? So if you represent the deponent, right, Blake Lively, you as her lawyer have every incentive to make sure that she shows up and that the deposition runs smoothly and she answers questions because you only want to have her sit once. If you screw around, the judge can make her come back and your client will be very, very mad at you. On the other side, if you're Justin Baldoni's lawyers, you have every incentive to conduct the deposition reasonably because your side gets 7 hours, all in, all done. If you argue with the witness or ask irrelevant questions, you are just wasting your own time in the only deposition you get. And here, it's of the plaintiff, right? That's the most important witness for you to depose, right? The judge is not going to grant you leave to take another deposition if you decide you need a mulligan.
Right. So Rule 30 provides that the person taking the deposition, that's Baldoni's lawyers, serve a deposition notice that specifies the date and time of the deposition. You have to give the other side reasonable notice, which is presumptively 14 days, but different jurisdictions set longer or shorter deadlines, whatever. Under the Maryland rules, it's 10 days, but the rule says you get to pick where the deponent will be deposed.
Right, that's the default rule. In practice, I can tell you, you pretty much never do it that way for a witness who is a party to the lawsuit, right? Instead, what you do as somebody who's noticed a lot of depositions in my day, right? Like you call up the other side and you tell them the witnesses that you want to depose and you ask their lawyer, when are they available? And you do that for two reasons. First, you do it because they're going to depose your witnesses, so you would like that reciprocal courtesy. And second, even if there's a massive imbalance, like one side is deposing a lot of witnesses and you're only deposing one, like it doesn't matter because if you can't agree and you have to go to the court on a motion to compel, the judge is going to expect that you have done it this way, the way that lawyers always do it. That didn't happen here.
Yeah.
And it didn't happen because Justin Baldoni's lawyer did the thing that he always does. And he said that inflammatory thing to the tabloids about, holding Blake Lively's deposition at Madison Square Garden and selling tickets. And you heard me twitch when I said it. Like, I can't tell you what an unbelievably stupid thing that is to say, right? Because however bad you think Brian Friedman is at the law, he knows the depositions aren't open to the public. He knows they're not going to be live streamed. Like, when you say that you are grandstanding to the press.
Well, he also took a swing at Vin Diesel's lawyer during a deposition.
Also not a thing I have ever done. And by the way, I like how at first when we were reading the plea, it wasn't clear from the transcript. And you thought that maybe he had punched Vin Diesel in the face.
Yeah.
Which we know that didn't happen because Brian Friedman is still alive.
Yeah, it's funny because it really wasn't totally clear because there was this document that appeared on the docket from a totally unrelated California case, and it was filed as an exhibit, and I'm like, what the hell is this? And it was talking about bad behavior by Friedman at a deposition, and it wasn't immediately clear why it was appearing on this docket.
Yeah, so here's what happened. Friedman called up and said, we'd like to depose Blake Lively at our offices. And Blake Lively's lawyers told Friedman, you seem to be a lunatic, so there's absolutely no way we're going to let you depose her at your offices where, you've threatened to let in members of the public. Like, depose her at ours, right? And by the way, Blake Lively's lead counsel here, they're from Wilcox, right? This is $1 billion multinational coat factory law firm. They have an enormous New York office on 7th Avenue in Times Square.
Yeah, and look, speaking of things which people know, which Friedman is pretending not to know, there was this drawn-out dispute because Lively kept saying, who do you intend to be at this deposition? That's one of the reasons that she wanted it at her own lawyer's office. And Friedman wouldn't say, right? Friedman wouldn't say who he intended to be in the room. And when you have a reputation, presumably deserved, as somebody who tries to intimidate people, right? Her lawyers were like, no, we're not doing that to her. And that was spun by his side as Blake Lively being a prima donna. But I'm sorry, if your lawyer takes a swing at opposing counsel and refuses to say who's going to be there, you're going to lose. That wasn't Lyman favoring Blake Lively.
Right. And again, let's point out, normal lawyering here would say, fine. We'll depose Lively and her husband, Ryan Reynolds, at your offices, but that means you're going to have to depose our guys at our offices.
Right, but this is not normal litigation. So Baldoni's lawyers made Blake Lively tee up a motion for protective order to have this deposition at Wilcox, New York, which she did and which Judge Lyman granted without discussion because when your lawyer tries to punch Vin Diesel's lawyer in the face, that's how it's going to go. So that brings us to Wednesday, July 16th. Brian Friedman was flying into New York from L.A. along with a bunch of other lawyers flying in from around the country. And everyone was assuming that Blake Lively's deposition was going to go forward as planned on the 17th on Thursday. But in the meantime, Judge Lyman starts ruling on a bunch of outstanding motions. And one of those is a motion to dismiss filed by a guy named Jed Wallace.
Yeah, and I should add that the Baldoni PR team apparently is trying to make something. This is very clearly Judge Lyman clearing the decks of a bunch of outstanding motions, right? Like there's nothing to be inferred from the timing here. Anyway, Jed Wallace. Wallace runs a small crisis public relations outfit out of Texas, and they were hired by Justin Baldoni's publicist. And Lively's claim here is that Baldoni asked his usual PR team to develop the plan to bury Blake Lively by planting negative stories about her in the press, right? And there are text messages that seem to support that allegation, bragging about his PR firm. It's called TAG, or the agency group. How they had friends on the inside at the Daily Mail. And there seem to be a lot of anti-Blake Lively stories at the Daily Mail.
Including today, yeah.
Yeah, right. So, that seems like a plausible allegation to me. Anyway, and then Lively claims that TAG, right, who are co-defendants in this case, hired Wallace essentially to be their, Nixon plumbers, right? She alleges that Wallace specializes in executing confidential and untraceable campaigns across social media and has a close relationship with Baldoni and Wayfairer's counsel, Brian Friedman. And then she says that the publicists hired Wallace, quote, to weaponize a digital army around the country, including in New York and Los Angeles, to create, seed, manipulate, and advance disparaging content that appeared to be authentic on social media platforms and internet chat forums. Now, Wallace's motion to dismiss didn't deny any of that, right? Didn't have to, right? Instead, what he said was, I live in Texas, and even if Blake Lively is correct, I didn't do anything in New York. They don't allege that I did anything in New York. And that is a motion to dismiss for lack of personal jurisdiction. And it, by the way, is perfectly appropriate, right? Someone can't just sue you in New York if you've never been to New York.
Right. And Lively's theory of personal jurisdiction as to why she can sue Wallace in New York is that Wallace conspired with Baldoni and Tag, and because they're in New York, Wallace is responsible for their actions as well and has to show up. Mm-hmm. Okay. Without getting too far into the weeds, that's a valid argument for Lively to make, but it requires a showing that Wallace knew his alleged co-conspirators were doing tortious stuff in New York. And Wallace submitted an affidavit that said, hey, these people are based in California. Nobody ever told me they were doing anything in New York. Either let me out or transfer the claims against me to a court in Texas where I live. Which is a good argument. So on Wednesday, Judge Lyman granted Wallace's motion to dismiss, but because that dismissal was on personal jurisdiction grounds, it was without prejudice. Unlike Justin Baldoni's complaint against Blake Lively, where he said, amendment would be futile except for on two really narrow claims because you got nothing. And so the internet, and I say this mostly referring to the pro Justin Baldoni Reddit forums,
the neutral forum, the overly biased neutral forum.
Yeah, it's so strange to watch it unfold. But they said, oh, well, Baldoni got dismissed with prejudice and Blake Lively's claims against Jed Wallace got dismissed without prejudice. And therefore, ipso facto, Judge Lyman is in the tank, which is... Look, I mean, I can understand if you don't understand civil procedure and if the lawyer influencers who are trying to, monetize your eyeballs are feeding you a nonsense story, you might think that these two things are the same. But according to the federal rules of civil procedure, they are not. So, okay, Judge Lyman gave Blake Lively 2 weeks until July 30th to amend her complaint against Wallace to allege that Wallace either did things in New York or knew that his clients were doing things in New York. Otherwise, he's out, donezo.
Right. And that's when things hit the fan. And we will be back to tell you all about that after our last ad break. Unless, of course, you're a subscriber at patreon.com/lawandgaspod or on Substack at lawandgaspod.com. And we're back. And so now, this is a really neat procedural geekery, right? So this happened because, as we said before the break, Judge Lyman dismissed Jed Wallace on July 16th. Blake Lively, under Federal Rule of Civil Procedure 30, was scheduled to sit for her one and only deposition on July 17th. Wallace is now no longer a party. And if you're not a party, you don't get to attend a deposition or ask questions.
Brian Friedman.
Right. But Wallace's dismissal was without prejudice. So sometime after Blake Lively's deposition, Lively would have the right to amend her complaint and bring Wallace back in. And you can see the problem. And so Wallace's lawyer is a guy named Charles Babcock IV. As far as I can tell, Babcock, perfectly good lawyer, not interested in turning this thing into a three-ring circus. He sounded completely reasonable to me on the hearings that we attended via telephone. So Babcock calls up Blake Lively's lawyer, Michael Gottlieb, again, who's one of the best litigators in the country, right? And says, hey, are you willing to have Blake Lively sit for a second deposition if you amend your complaint and add us back in? Which makes sense. It's what I would do if I were Jed Wallace's lawyer. But Lively's lawyer says, absolutely not, which also makes sense. That's also what I would do if I were Blake Lively's lawyer, right? So here's the solution that Gottlieb offers. He says, look, if you guys agree to a protective order, we'll sign a stipulation that says, hey, you might be a party, and we're going to let you, and only you, ask questions tomorrow as if you were in the litigation. But we don't want to set the precedent that, like, non-parties can show up at her deposition, because we've already had this lunatic say, well, I'm going to sell tickets on live stream, right? So, and Babcock says, cool. So problem solved, right? Well, not so fast, right? Because remember, Rule 30 says that each side gets 7 hours of questions. So that means anything that Wallace's lawyer asks comes out of that 7 hours of time for Justin Baldoni's side. So then when Babcock calls up Brian Friedman, who, is on his side and everything else, and explains the deal and says, what I'd like is half an hour or something. Friedman says, absolutely not.
Even though before Lyman dismissed the claims against Wallace, they would have had to share their 7 hours with Babcock anyway.
Right. But now I infer, right? I don't know, but I infer that they're getting greedy, right? I think they want the whole 7 hours to themselves.
Yeah, I think that they do, but I'm not sure that I would characterize it as greedy. I mean, right? That's a substantial portion of the time. And why should they share it with somebody who's not a party to the case anymore? Or there's another interpretation, but you finish it and we'll talk about that in a sec.
Well, whatever happens, now there's no agreement. And now the parties have to run to Judge Lyman at 5 p.m. on July 16th for an emergency hearing the night before Blake Lively's deposition. And Friedman's local counsel, Kevin Fritz, says, hey, Judge, we got a perfect solution for you. Why don't you just let Blake Lively's deposition go forward tomorrow? And you could also issue a ruling that if she amends her complaint with new allegations against Jed Wallace, bring her back, have her sit for a second deposition. They could get an extra 2 hours or something. And Judge Lyman says, absolutely not.
Right.
Okay, so long story short. Well, long story shorter, right? So what Lyman says to Blake Lively's lawyers is, why don't you just file an amended complaint tonight? In fact, it can be identical to the one that I just dismissed, the one that's on file right now. It is a placeholder. Just add Wallace back in as a party. Then, as a matter of law, he'll be in. So I don't have to do anything. And the wrinkle there is, under the Federal Rules of Civil Procedure, you get one free amendment of your complaint as of right without leave of court or the other parties. It's Rule 15. And even if they had, at this stage of the litigation, you're going to have to go back to the court. So Judge Lyman says, right, I anticipate this. I'm going to authorize in advance what you file tomorrow. You get another free amendment on top of that. You file this placeholder in the next few hours. And then anytime before July 30th, you can amend your complaint to add what you actually want to add to include the allegations that you need.
Yeah, and I think it's important to understand this. I know this has been a lot of in the weeds stuff. It's important to understand this as everybody in this situation came to the table in good faith, and they were trying to craft a workaround for this problem because nobody wanted to give up something that they were entitled to. And that was a rational position for everybody to be in. And so Judge Lyman was like, well, suppose that we do it like this. What are some ways that we as lawyers who are supposed to be creative thinkers, what are some ways that we can kind of paste this together so it doesn't go totally sideways? So after the hearing, Blake Lively's lawyers file a notice that says counsel for the parties met and conferred and mutually agreed that in light of the court's order dismissing the Wallace parties and Ms. Lively's right to amend the complaint on or before July 30th, Ms. Lively's deposition will be continued until July 31st. So the thing got postponed.
Right. So here's what that means in practical. It really does give everybody the maximal amount of what they want, right? Because right now, nobody knows if Blake Lively is going to amend her complaint to add Wallace back in or not. If she does, Baldoni's lawyers will go back to that timeshare of the 7 hours on July 31st, right? But she's got to add him by July 30th. If she doesn't, however, Friedman and Fritz will get that full 7 hours to themselves. They won't have to share it with anybody. And that, I think, is why they agreed to postpone Lively's deposition by the 2 weeks, right? They would rather wait that extra time and maybe get the full 7 hours than have to give up half an hour now, which totally makes sense when you were talking about the practice of law. But it totally contradicts the stuff you've been saying in the press, right? If you think Blake Lively is not showing up for her deposition and you're on a plane to go depose her tomorrow morning, you give up your half hour, right? You'd rather have 6.5 hours than 0.
Yeah, I kind of read it different and from reading a lot of this correspondence, which is that the people who really wanted the postponement were not Lively at all. It was the Baldoni parties. And so I think they were just as happy to get it. And I don't blame them for not wanting to give up their half an hour to somebody who may or may not be a party to the lawsuit. They're only going to get one shot at her, and they're on the hook for potentially hundreds of millions of dollars in damages. So yeah, you want the extra 30 minutes. So there's one more issue that's floating around, and it's so strange for us to watch it be metabolized by non-lawyers who are really personally invested in this case. And it has to do with interrogatories. It has to do with discovery. Because what Baldoni wanted was a lot of really personal financial information about Blake Lively's net worth. And she wanted to give him a smaller set of her financial information. And look, her lawyers I didn't think it was a particularly good argument. And as it turns out, neither did Judge Lyman. Her lawyers argued that she didn't have to hand over information about how her various businesses were damaged because that was going to come later by her expert witness. And the court said no.
Right. And so the court ordered Lively to A, respond to interrogatories about how she intends to calculate her damages, and B, to produce the documents that would support those damages, including the income and the revenues from her businesses, right? Because she said, I've lost money because you've been smearing me in the press. And critically, the way this interacts with the deposition stuff, she has to produce those answers and those documents within 7 days by July 25th. So they will be in Brian Friedman's hands in advance of her deposition, so she can be asked about them during her deposition, which is, another reason that buttresses what you said, that like from a legal perspective, probably wasn't Blake Lively who was asking to postpone things.
Right. But Baldoni lost on another argument, which is that he wanted all of her personal net worth, about all the properties that she owns, basically, her retirement plan, all of that stuff. And Baldoni's argument was that he had to turn that information over to her, so turnabout is fair play. And Judge Lyman said no. And the reasoning here is really interesting and susceptible to misunderstanding. So basically, the reason for the different treatment is that Blake Lively is the plaintiff, and she alleged that Baldoni's bad faith behavior should subject him to punitive damages. So to punish someone, you need to know their net worth because the punishment functions as a disincentive. Right. And $50,000 is no disincentive to somebody like Elon Musk or even maybe to Alex Jones. It's a strong disincentive to most people who have a W-2. But Lively, as a plaintiff, cannot be subject to punitive damages. And so her net worth is irrelevant because nobody's going to be trying to, assess how much pain she has to go through financially as a disincentive to bad behavior, because her bad behavior's not at issue here anymore because Baldoni's case got dismissed, which is why this whole we had to give ours, why shouldn't you have to give yours? That was a bad argument.
Yeah, and also why the Justin Baldoni is secretly it's fine that his counterclaim got dismissed. Well, no, it isn't, because now, as a matter of law, you've conceded that she owes you zero, and therefore you're not entitled to her detailed financials. Okay, so Liz, I got to end this segment with asking you about whether you think Blake Lively is going to add Jed Wallace back in as a defendant or not.
She might, right? I mean, look, the allegation here is that he was seeding all of the social media platforms at Reddit, that he was kind of making sock puppet accounts to seed horrible shit about her being a bitch and a diva and whatever. And so I think it would be interesting. I mean, he's not going to have any money for damages. He's not the pocket. The big pocket here is Steve Sarowitz, the co-founder of the movie studio with Justin Baldoni, who inexplicably to me does not have his own lawyer. I mean, I don't know. What do you think?
Yeah, I agree with that, right? If you were just asking about the claims, the claims against Wallace kind of seem the most remote, and there's a chance, right, that she could add him back in and he could file to, move to dismiss again and win, or that he could survive a motion to dismiss, but still get out on summary judgment in a couple of months, right? Like, so I think there's a lot of downside risk for her. On the other hand, if you think his testimony is super inflammatory and you want to ensure that he's a party witness, right, that the court has the power to compel him to attend under pain of sanctions, you want to keep him in. So I think it's going to be interesting. I think we will know in 2 weeks, and I still can't look away.
I know. I know. It is such a weird thing to see all of it swirling around, especially because you are much less online than I am. And so when I said, oh, no, he's 100% winning the PR war, you were like, he is? How is that possible? His lawsuit is garbage. And I was like, no. And then you made fun of me for a little while for watching these forums. And now you're like,
I talked to some 20-year-olds.
I know. And now we both are like, look at this crazy shit that's going down. Anyway, thank you for indulging our weird lawyer hobby and giving us a little break from talking about the rest of it. Okay, that is going to do it for us. Thank you guys for hanging out with us, and have a lovely weekend. If you enjoyed the show, can I ask, would you please give us a nice review and 5 stars on your podcast platform of choice? All right, we'll see you guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.